Welcome to Real Talk San Diego, Real Talk Solana Beach, and your Wealth Hour with my co-host,
Karen Casino,
and myself, Ryan White. Today, we're going to talk about the importance of disclosure and how to invest for your future. Joining us today, Meredith Lewis and Radia Hunter. Meredith, let's start with you. We've talked several times, about the different options one might have when going through the divorce process, but more specifically this time, going to hit on the disclosure process, which I think you're going to tell us it's just as important across all methods, but go ahead and tell us about the process.
So disclosures are required in any family law case, whether you're in litigation, mediation, collaborative. It's a requirement under the statute and family law cases. And it's very important because it allows both parties to be on an equal footing in terms of knowledge of the estate, income, assets, and debts. And there are 4 forms in the disclosure documents,
Okay.
and the 2 main ones are the schedule of assets and debts and income and expense declaration. And it's exactly what the name says. You list all your assets, your debts, and then the income and expense declaration, you're listing your income, your expenses, and then you have to provide supporting documentation to show that. And it is, no matter what, even if you completely agree on everything in your case, you still have to prepare and exchange those documents.
We're talking with Meredith Lewis. She is a family law attorney and CDFA, Certified Divorce Financial Analyst, with the law offices of Meredith Lewis, and her website is mglfamilylaw.com. mglfamilylaw.com. What's the G? Middle name, I'm guessing?
Gilbert, yes.
Gilbert.
Yes.
mglfamilylaw.com. Okay, tell us again. You mentioned 4 major ones. Go through those one more time, because I think that's a relatively important part.
So there's 4 forms in
Uh-huh.
the disclosure, and you do disclosures as early on as possible in the case, in the beginning, before you can really get into the details if you're in mediation or another type of ADR.
Okay.
The schedule of assets and debts, which lists where basically you're listing all of your assets and your debts, community property and separate property. Even if you don't think the other person has an interest in it, you have to list it.
Okay.
And then whatever you list on your schedule of assets and debts, you have to provide a statement and documentation. There's the income and expense declaration, where you are setting forth, and this is all under penalty of perjury, your income, what you earn. You have to provide your last 2 months of pay stubs if you're a W-2 employee. If you are self-employed, you need to attach a Schedule C. You have to show proof of your income. And then the second part of that form is listing out what your expenses are, because when spousal support is an issue, expenses of the parties is one of the very key factors. The 2 other forms, there's the actual declaration of disclosure form, and there's a bunch of questions that it asks whether or not you have been, or the community has been offered the chance to go in on some sort of business deal and offer to invest in something. You have to disclose that, even though it may not be a tangible asset. The offer, or to do that, has to be disclosed. And you also attach your last 2 years of tax returns to that. And then the last form is essentially proof of service. That is the only one that you actually file with the court, showing that you have prepared and exchanged those documents. And both parties have to do those documents.
and you have to do them at the beginning. We call them preliminary disclosures, right? And then technically you're supposed to do it at the end too, but a lot of people, what we call, waive that responsibility, but it is preliminary, and it's meant to be done at the beginning of the case, right?
Absolutely. There's the preliminary declaration of disclosure, and there's a certain time period after you file your petition or your response that you should do them, and it's really the first step. If you go to trial at the end of the case, you have to do a final declaration of disclosure 45 days before trial. If you are in mediation or doing a collaborative divorce or just some sort of settlement, you can waive the exchange of the final declaration of disclosure because the parties feel comfortable enough that they know the estates. Even though you do have this preliminary and final declaration of disclosure, if there's any major changes, you have the duty, though, to update and advise the other party. And not wait to the end when the final declaration of disclosure is done.
Makes sense. Talking with Meredith Lewis, family law attorney and certified divorce financial analyst. Her website is mglfamilylaw.com. That's the website, mglfamilylaw.com. Now, being in real estate, certainly the concept of disclosures is not one that's foreign to me, and we are commonly advised that there is literally nothing that does not qualify. If you have to ask me, should I disclose this? My answer has to always be yes. So I'll kind of give you a little bit of softball. Is there anything that I don't necessarily need to disclose?
In my opinion, no.
Figured that's what you would say.
And if I have a client who I know has stuff that he or she is not disclosing, I generally will choose not to continue to work with that client, because that's that person's choice to not disclose it. But the sanctions and the penalties that a person can face by not disclosing assets, you can literally, if a court finds a disclosure or lack of disclosure so egregious, they can award 100% of that asset to the other party. And you're not starting out, especially if you're trying to settle the case, you're not starting out on a good foot when you're trying to hide the ball and not being open and honest.
Now, I don't want to put words in your mouth, but seeing as to, of the processes that one might go through, you mentioned that you do a lot in the collaborative space. And it certainly seems to me that upfront disclosures are paramount when going through that process. Why don't you talk about that a little bit and the importance of that?
Absolutely. So in the collaborative process and in mediation, one of the very first things you do is start working on those disclosure documents. In mediation, for example, sometimes the mediator will do it and they'll work together with both parties to do disclosure documents. Some mediators do joint disclosure documents. My preference is that each party really do their own, because it's their own legal pleadings. In collaborative, you have a financial neutral who's a CFP, CPA, and also a CDFA, and that person, the first step in a collaborative case is to meet with the parties to go over the assets and the income of the parties and prepare those disclosure documents. And that's really the springboard for having discussions about settlement, whether it's mediation or collaborative, about support, temporary support, and eventually permanent support, and property division and debt division.
Now, you touched on this, but I think it's relatively important to not disclose or to, we hear all the time about people, and I would think this is a lot of what people fight about in court, is lack of disclosure and what truly is a business opportunity, as you mentioned, right? What kind of penalties, and again, you touched on it, but I think it's worthy to hit again, what kind of penalties come into play should I not disclose my Maserati or my business venture of a Brazilian blowout shop?
Well, the court has a lot of discretion. I mean, they can consider it a missed asset and divide it one half each. The court, though, like I said, absolutely has the ability to award 100% of the undisclosed asset. There's a famous case, the Rossi case, I believe, where the wife did not disclose lottery winnings, and that's an asset, the winnings of it. And it was so egregious that she lost that asset. It went to the husband. And that's an example of you need to disclose, because if there is a financial on the other who's working with the other person, or an attorney who understands financials and notice things may not add up on the other side, they're going to find out. And that's not something that you want to deal with if you have to go to court.
I wouldn't think so. We're talking with Meredith Lewis. Her website is mglfamilylaw.com. mglfamilylaw.com. Now here's one that's kind of near and dear to what Karen and I do here. Let's say a client has filled out their list of disclosures, but they don't know the value of certain assets, like businesses, cars, houses. What do you do then?
So in a lot of times in the preliminary declaration of disclosure, you don't necessarily know the value of everything. You know the value of your bank account, most likely, because you have statements, hopefully. But things like businesses or a house, you may not know what that is right now. And so what you often do will put to be determined in, for example, your schedule of assets and debts. And that's where it's really key to bring in experts such as you, Ryan, and you, Karen, to try to work on what a value could be. For example, if there's a business and say neither party has any idea what the business is worth, though the person who operates a business will often say it's not worth anything. There's always a value somewhat to the business. Somebody like Karen, who values businesses, can come in and look at all the paperwork and all the documents that she needs to come up with a marital value, which is different than, for example, resale value. On houses, where somebody professional like you would come in, parties can if one person is going to keep the house and it's not going to be sold, you need to have an agreed upon value.
Mm-hmm.
People can go and get a formal appraisal, but it is incredibly helpful early on in the case to have somebody like you give comps, give an
Sure.
idea. So at least that's a starting point. And if the parties are comfortable that that's an accurate number, then they save the cost of doing a formal appraisal.
Right. Makes sense. We talked about the collaborative approach. Now tell us a little bit how the disclosure process works through the mediation approach.
The disclosure process works actually exactly the same in every case. Mediation, collaborative, litigation, we're just trying to work it out. You need to disclose. You need to update changes. You need to advise the other party of opportunities. It should be done earlier on in the case. And what I've seen happen, not in collaborative cases, because collaborative cases are very strict in terms of timelines and steps, but in some mediations I've seen where parties have come to agreements without disclosure documents being done. And that's slightly alarming because parties are agreeing to stuff that they don't even know what exactly they're agreeing to. So in terms of how the disclosures are done and the timing, it is the same in every case. My hope is that in mediation and certainly collaborative, the parties are incredibly forthcoming about their assets. It may be a little bit harder if the case starts out as litigation, but those rules apply no matter how the case proceeds forward.
So disclosures, important in any method. How about the importance of having an expert when going through the mediation process?
The majority of my cases I do have some sort of expert. I focus a lot on financial cases, so and that's sort of my passion, but I am not a financial expert. And so it is key to have somebody, whether it's somebody to come in to value the business, to look at an analysis, income available for support when one person is self-employed and they say, oh, I don't make any money, I just pay myself $30,000 a year, but they happen to pay their nanny through the business. That's not a business expense, that's added back into their income. And there's so many different things. If parties have stock options, one party works at a company that provides that as a benefit, you need an expert to come in to do those evaluations. Because attorneys, we understand what that is, but that's not what we do on a daily basis. And I think you're doing your clients a disfavor by not having an expert do that, because you know it'll be done with the right expert, it'll be done accurately.
And if the disclosures are done first, then you can look at the disclosures and say, oh, you know, here's a business, here's some stock options. You know right off the bat that there needs to be some additional assistance. And then that gets done, and then they sit down and try and resolve the case. Where you were mentioning earlier, sometimes we get involved in mediations and everybody's working together and, oh, we'll worry about the disclosures later. They might even come up with a deal based upon what they thought was there, and then when we get the disclosures we realize that the values are actually different, or there were more assets that they didn't tell us about. And so that makes it very difficult when people have reached an agreement on a number and it turns out that actually the number should have been higher or lower. And so that's really not the order, and that's why the order should be disclose first, have people work on it, you know, get documents, ask questions, then negotiate a settlement.
And the scenario, exactly like you said, in that, if the actual assets are different than what you initially believed because there wasn't disclosures done first, you may have to go back to square one, or there's animosity because one party thought they had a deal, it'll fall out of mediation and they end up litigating anyway. Not the best way to start any type of mediation.
Yeah. It does seem relatively simplistic. In order to split things in about 50-50, you kind of have to know what you're splitting.
Exactly.
I mean, it doesn't seem overwhelmingly complicated from that perspective. Now, filling out the forms, I see there's some complication in there. Okay, we'll talk with Meredith Lewis. She's a family law attorney and a certified divorce financial analyst. Her website, mglfamilylaw.com, mglfamilylaw.com. Now, tell us some good stories about how this process worked.
Well, I don't know if it's a good story for everybody involved,
Okay.
but
Okay.
I do enjoy working on cases where something just doesn't seem right and we need to dig a little bit deeper. And a case that comes to mind, I represented one spouse, and the other spouse said that he was disabled and he was receiving disability income and he couldn't work. And however, his expenses that he was paying were thousands and thousands more per month of what he was receiving disability income, and he didn't have any credit card debt, and support wasn't being paid yet. To me, that's a
Okay.
red flag.
Okay.
Who's paying your bills? Where is
Right.
it coming from? His disclosures were incredibly inaccurate. Didn't provide everything. I sent subpoenas to bunches of different banks. I noticed that his schedule of assets and debts didn't match his discovery responses or his big holes. And then we got all these subpoenas back, and he actually had he was investing in an area which is very hard to track in like Bitcoin currency, but he essentially was earning over $200,000 a year, but he didn't disclose it because it's hard to find that because it's in a wallet,
Yeah,
basically in the
I can
cloud.
see how that'd be hard to
Yeah.
find. You're right. It's hard to find.
He got nailed. So,
You found it.
Yeah, so we found it.
You found
And so that's not a success story for him, but it was for my client.
Your client,
yes.
yes.
And it was a lot of fun because I knew something was off. It just didn't make any sense. So.